Hello, I'm attorney Jonathan Blecher. I'm a criminal defense attorney specializing in drunk driving defense here in Miami, Florida. I'd like to talk a little bit about what penalties there are for various levels of DUI in the state of Florida. There are minimum penalties that a court must impose if an individual is arrested, convicted of DUI. The first would be a minimum fine of $500 with court costs and surcharges comes up to over $1,100 for a first offense. An individual will be placed on 6 months reporting probation. There would be a 6-month driver's license revocation, 50 hours of community service, successful completion of a 12-hour alcohol and substance abuse education program, 1 session of the Mothers Against Drunk Drivers Victim Impact Panel, and a 10-day immobilization of an individual's motor vehicle. A lot of people have asked about the immobilization law and they wonder what that is. Well, under Florida law, there is a 10-day vehicle immobilization which must take place at the end of an individual's probation if they're convicted of DUI. Essentially what happens is a company comes and puts a club or a boot on the person's car, parks it in front of their house, and for this they pay for the privilege about $100 for this service. Certainly there are consequences to a DUI that will extend beyond even the minimum penalties. A DUI is a criminal conviction. A person that gets convicted of DUI will have that on their record for life. It can never be removed. And certainly there will be increased insurance premiums that will result for any DUI conviction. And remember, a DUI conviction can never be removed, sealed, expunged, or erased from an individual's record. Sometimes where the probation department or the DUI school believe that a person has an alcohol problem, they may also be required to attend alcohol education group therapy sessions beyond the 12-hour substance abuse program. For multiple DUI offenses, the penalties become even more strict. For a second offense within 5 years of the date of a prior conviction, there is a mandatory 10-day minimum jail sentence up to 9 months for a second conviction within 5 years. In addition, there would be an ignition interlock device placed on the person's car. And I'll talk a little bit more about ignition interlock devices in another video. There is additional penalties and more serious penalties for a third offense. Legislature in the state of Florida a few years ago changed a third offense DUI from a misdemeanor to a felony. So a person that has 2 prior DUI convictions and picks up a third and gets convicted of that can be charged as a felon, and there would be a maximum penalty of 5 years in state prison for a third offense. For more information about these and other DUI-related topics, please visit our website, DUILawdefense.com. I'm attorney Jonathan Blecher.